Hello, welcome to Pre-Publication Review in the Age of AI. I'm David Shraga, Secretary of the Beverly Hills Bar Association's Entertainment Law Section. I'm very pleased to be with you here today. Before we get started, we wanted to acknowledge Lawyers Mutual Insurance Company, a longstanding sponsor of the Entertainment Law Section. For 5 decades, Lawyers Mutual has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that LMIC is directed by a group of dedicated lawyers themselves. That means they are uniquely skilled and have folks on the team who are among the very limited number of certified legal specialists in the state of California in the area of legal malpractice. And as an added benefit, that specialized team operates a hotline that's available to policyholders who have pressing questions that they need immediate help with. They offer special rates with competitive premiums for a wide range of areas, including entertainment law. We have come to know these folks here at Beverly Hills Bar very well. They are a great partner, and you can learn more about them at lawyersmutual.com. I'm now delighted to introduce our highly accomplished panel, Dale Cohen, Chris Perez, and Amanda Harris. Professor Dale Cohen is the director of the Documentary Film Legal Clinic at the UCLA School of Law, where he leads student clinicians in providing pro bono legal services to documentary filmmakers, and he serves as senior special counsel to Frontline, the award-winning PBS documentary series. His extensive career as a media lawyer, litigator, and news executive has spanned organizations including NPR, Radio Free Europe / Radio Liberty, Cox Enterprises, and the Tribune Company, as well as litigation partnership at Sonnenschein, Nath, and Rosenthal, which is now Dentons. He earned his JD cum laude from Northwestern University School of Law and is the co-author of the textbook Media and the Law, currently in its second edition. Next up, we have Chris Perez. Chris is a partner at Donaldson Callif Perez, where he represents independent producers, production companies, writers, and other creative clients across all aspects of film and television development, financing, production, clearance, and distribution. He is co-author of the 5th edition of Clearance and Copyright, the industry's leading text on right clearances, and he's been recognized by Variety, the Daily Journal, and California Lawyer for his work on landmark DMCA exemptions for filmmakers. Chris also serves as a board member of the International Documentary Association and as an adjunct professor of law at USC Gould School of Law. And finally, we have Amanda Harris. Amanda is an associate attorney at Jassy Vick Carolyn LLP. Prior to joining the firm, she served as a business and legal affairs exec at a premier talent agency where she provided global representation to clients across film, television, publishing, digital media, commercial endorsements, audio, theater, and book-to-screen adaptations. Before that, she was an associate at a widely respected private law firm here in Los Angeles, where she maintained an active pro bono practice alongside her commercial litigation work. Amanda earned her JD from Harvard Law School in 2023, where she was recognized with the Dean's Scholars Award. She received her BA with honors from Stanford University in 2019. Amanda is also the co-chair of the BHBA's AI in the Law section and the organizer of this great panel. And as for me, I am privileged to moderate this conversation today and being the company of these highly accomplished folks. For my part, I am a mediator at signature resolution with a background as an entertainment litigator in private practice, a business and legal affairs executive in the Hollywood studio system, and I've also enjoyed handling a range of business and employment disputes and settlements along the way. So with that, let's get started. First of all, thank you everyone for being here today. It's really a pleasure to have you.
Thank you. Thanks, everyone.
Thank you. Thank you. Let's just get started today by giving our audience kind of a quick map of where we're headed today. And, to extend that analogy for lawyers who are working with filmmakers and vetting documentaries where AI is involved, we really are in uncharted territory. Each of you is at the forefront of this area and in overlapping yet distinct ways. And I think that the combination of your experience really provides a terrific perspective on this topic. Certainly, there's no shortage of conversation about AI in Hollywood these days, but we're here to focus on the documentary space. And, to frame this discussion for folks working in documentaries, we know that for creators and practitioners, there's very tangible and very public implications to how AI is adopted in their work and to how they create and also relate to their audiences. There's also an equally important practical aspect of this that affects how we think about clearance, establishing rights, working with AI, and distributing this work so it can be seen. And that's really where our lawyers come into to play, of course. And so today, we're going to talk about what lawyers and filmmakers need to be aware of and potentially to be careful of, how they protect themselves legally, and also how they protect the integrity of this work they're all really very privileged, I think, to feel that we can support and be a part of. So, to start our discussion today, maybe we could get into a real world example from the documentary world that I think will give the audience a very tangible sense of the issues that AI is presenting in our community here today. Amanda, why don't you set the stage by telling us about the What Did Jennifer Do controversy from 2024?
Absolutely. Thanks, David, and thanks to my fellow panelists. This is going to be a great one. So, yeah, I thought we'd start off to illustrate sort of what's at stake for filmmakers and various stakeholders in these documentary process. The What Jennifer Did example illustrates a lot here. So, for those who don't know, What Jennifer Did is a docuseries on Netflix. It highlighted the case of against the main person in the documentary, which is Jennifer, who is alleged to have murdered her parents, along with three co-conspirators. And the real controversy for our purposes is a couple of people online after the documentary came out on Netflix and started receiving a ton of views accused the documentary makers of manipulating a couple of key images in the docu-series with AI. There was an extensive online discourse about backgrounds that looked sort of different or smiles that looked off because one tooth was, much more elongated than another. And it really caused a lot of backlash for all the folks involved with the program, for Netflix itself. And I mean, in the interest of fairness, so Netflix, as far as I'm aware, has never commented publicly on this controversy. The executive producer of the docuseries denies any AI manipulation, but just the extensive discussion and discourse around this highlights sort of the stakes for people involved in these projects and, raises an issue that I think we as lawyers and counsel should look out for.
Yeah, I mean, it's a fascinating example because there were aspects of this, as I understood the controversy, where the filmmakers were trying to reflect something like an emotion, for example, that they would make the subject look happy, um, and sort of in the process of trying to tell the story. But I think really, what it comes back to and comes down to for documentary films is we're really talking about an issue of transparency and trust and how that can implicate sort of the relationship with the audience and also potentially lead to a backlash from the audience, right? So I guess Chris, maybe we could start with you. You've worked on some very distinguished documentaries, of course, and you're very much in this conversation with clients as they grapple with these issues. As Amanda explained, there wasn't disclosure in this case. There was controversy after the fact. If disclosure is often or not necessarily strictly required, how do you advise clients on when and how to be transparent about how they're using AI?
Yeah, it's tough because this changes day to day, right? What was okay to an audience maybe 6 months ago, or not okay 6 months ago, maybe they've gotten used to it because of the dramatic increase in the use of AI 6 months on. But where we're still living right now, I think, is in an age of uncertainty around the use of the technology, but also how it might appear, and particularly in a space like documentaries, right? Where people, regardless of what platform it appears on, if it looks like a doc, it smells like a doc, they expect certain standards to be upheld. And, I looked at a lot of the comments on what Jennifer did in terms of the backlash, and it was all over the map in terms of why people were upset. But I think people were mostly upset because they just expect authenticity, right? So as a filmmaker, these are difficult decisions to make, right? Because on the one hand, you could have a situation where maybe the photograph has a blemish, right? And something in the background you don't think the author or the audience needs to see. Okay, AI can do a great job of removing that. But at the other end of the spectrum, you have very obviously wrong things, right? You make the person do something that they didn't actually do, in which case there is potentially a legal claim like defamation or false light. But the middle area is the most interesting because filmmakers now have the discretion to do so many little tweaks that maybe in their opinion doesn't really change the basic nature of the truth as they're presenting it. And in those cases, there may not be any kind of legal remedy for the person in the photo, but the audience definitely expects to know that that is happening. And I think that's still the case. The APA, I think we've mentioned before, has a great set of guidelines on how to be transparent, but I don't think that at this point there's agreement on exactly how to be transparent, right? Some people say you got to put something in the lower third, almost like this is a reenactment that you've seen in years past. Other people say, well, you can just, put it in the end crawl with everything else. But most people would say, well, people don't watch the end crawl anymore, right? Um, so that's not enough transparency. So I don't think there's one right answer in this regard, but I do think that it is essential that attorneys, number one, know that their clients are actually engaging in the use of AI with particularity, and then having a conversation with the filmmaker about what creatively they're willing to do in terms of transparency.
There must be a real tension between the need to craft a compelling story sometimes, right? Versus the need to maintain the integrity of the work. And Dale, I saw you nodding your head when we were talking about the critical importance of trust within the community and trust between the filmmakers and the audience. And I'll just add to that I think your perspective on this is very interesting because you're working with students at the UCLA Film Clinic. I understand that the way the clinic works is filmmakers are paired with teams of law students who follow them through the process and advise them along the way. But we're talking about a generation that's grown up with social media, that's grown up with these AI tools and has a different relationship, I think, to authenticity in the overall marketplace. How does that play out in how you're advising clients and how your students are working with filmmakers when it comes to these issues?
It's interesting because for the most part, even the younger generation is looking for the same kinds of transparency and credibility in documentaries that Chris and Amanda and you have already been talking about. So when I first got started with this clinic and I was working with Frontline, which is kind of the gold standard of journalism in documentary, one of the concerns my colleagues at Frontline had was you're going to be working with these newfangled filmmakers and they're not going to have the same kinds of standards. How are you going to do both of these things? And I'm pleased to say for the most part that giving the same kinds of advice to the newfangled filmmakers and the traditional journalism filmmakers in the documentary sphere is well received by both sets of the filmmakers because they are concerned about what Amanda and Chris have already spoken about, which is credibility in the marketplace. But the industry has also got its own way of enforcing transparency and ethical storytelling. As Chris mentioned in our pre-meeting, studios, distributors, platforms, insurance companies are all starting to ask questions about the use of AI, and they want specifics. They want to know what's being presented as it really was, what's been created synthetically, and how are those decisions made, and how can they evaluate what the risks are. And so I think all of us would say that we're very fortunate to still be able to say, even in this age of AI, that ethical storytelling is still the most important thing, both for the credibility of the film and also for protecting yourself against legal claims, whichever legal claims there may be. And it is true, there's some tension there sometimes with filmmakers who say, gee, I don't want to ruin the shot by having to do this, that, or the other thing. But I think the history and experience suggests that the best way for them to defend themselves, for us as lawyers to help them defend their films, is for them to follow really good ethical storytelling, which means transparency with all of their partners as well as the audience, but also really, really solid fact checking and vetting by lawyers, by fact checkers to make sure that what's being presented is in fact credible.
Yeah, it kind of comes back to this notion that in some sense, the more things change, the more they stay the same, right? The same fundamental core values that I think have probably animated your conversations with clients over many years are still present there. But as Chris mentioned, the standards are evolving and they are changing. And Chris, I just think it's so interesting. You mentioned the APA, the Archival Producers Alliance. I know you're a member of the advisory board for their generative AI initiative. And so for folks out there who are looking for guidance about how these standards are evolving, what is happening in that conversation? Because the the law seems to always be behind the dialogue, right? In terms of what we are actually the guidance that is out there. We can't necessarily wait for the courts to rule on all these issues when claims come up. What's emerging in terms of standards, and what are some resources folks
Yeah.
can keep an eye
Yeah,
on?
I think the APA is doing such important work for exactly the reasons that you mentioned is that yes, the old adage that the law is always a few years behind the technology. I almost feel like that's just not enough these days. It's just like not emphatic enough. It's happening so fast that courts, as soon as they get to the point of making a decision, the technology's changed again, right? And so I think the work of the APA fundamentally is trying to, first of all, educate people, specifically film producers and other people in the industry, about the importance of transparency, right? Because people are using these tools, whether we know it or not, right? I've worked on many films, I'm sure, where filmmakers were using AI tools and they just didn't tell me, right? Because they were afraid, which we can talk a little bit about that a bit later. But I think it's education, right? Letting people know that um, the use of these technologies has real consequence, especially if audiences are unaware that they're being used. But it's also generating an understanding of the importance of real archival materials, right? When I say real archival materials, I mean like, if you're making a film on the civil rights movement and there are particular photographs that depicted certain events or archival footage that was the only videographer there that day, that material has real value in our culture. And I think the APA has done a great job of broadcasting to the general public that that has to continue to have value, right? At what point is this AI generated material going to substitute for the real thing? And when it does, our audience is aware when it's happening because there's no turning back. People are going to create archival materials using AI, but I think helping viewers understand the distinction between those two things, between that videographer was there versus this was, you know, Sora or something like that. Um, just educating people, I think, is the most important thing that they're getting into.
It's a really interesting distinction between the actual archival material and sort of the recreation of a historical event, because you mentioned previously the role of reenactments and how often that comes up in documentary films. And Amanda, this one's for you. You've got a unique expertise in the sense that you're actually litigating these cases as well. I know we have some folks with litigation background here too, but you're sort of the current trial lawyer in our panel more so, I think. And so I guess from your perspective, how do issues like transparency, disclosure, dealing with reenactments, how does that play out in the context of litigation? Are filmmakers more concerned about, that exposure or the authenticity issue, or is it a delicate dance, I imagine?
Yeah, it's a great question. Very much a delicate dance. I mean, I think Chris and Dale both alluded to this to different degrees, but with this issue, a lot of the concern isn't strictly legal. There's the subset of cases where people can bring defamation or false light claims or other torts of that nature. And then there's sort of the stuff in the middle where people are upset. And things can still be very expensive for an artist, even for, what we might say is a frivolous claim, um, or something that lacks legal merit or whatever. If it draws enough ire, it could still be expensive and chill speech in a way that filmmakers and other people who make documentaries don't really want. So I think it's definitely critical, to emphasize, look, here's your legal exposure, here's your audience exposure, here's your industry exposure, when vetting a project on the front end, so that the people making the film can have the full tools they need to make the choices they want. And different filmmakers are going to come out in that calculation differently. But I think our, primary obligation as lawyers is not just to spot the legal risk, but also the other things that could impact the project down the line.
It's a great answer. And obviously, you obviously handle work on the front end with advising productions too. And so I imagine part of that conversation is going on the entire time in terms of, hey, here's a potential way to mitigate what your risk is going to look like. Same traditional conversation that's always been happening. So let's jump into something that Chris alluded to, and more some of these nuts and bolts issues that I think lawyers are dealing with on the vetting side today. Chris, you mentioned editing, and this is one area that I think AI has really affected. We think about the editing process. There's an interesting dynamic I think that exists, particularly for documentaries, because for folks who come from potentially the scripted side of the business, they're working with platforms. This very sort of highly interactive process is happening with buyers and distributors where they're talking about what are you doing? How are you using these tools? Are we comfortable with it? I, I think a lot of times, though, for documentary filmmakers, they're working with their lawyers, they're putting something together, they deliver a cut, right? And you're in a different position, I think, when it comes to what you're putting out in the world. So, um, sort of, what are the questions you're starting to ask yourself, or maybe you're asking your clients when a cut comes in as you think about how the editing process is changing?
Yeah, well, first of all, I'm asking whether they're using generative AI programs, right? And I think that's a lesson to be learned because I think at first we just assumed people would tell us, and then we realized, okay, we have to be very direct with this question. Okay, you're using a particular program. Let's take a look at the terms of service, right? Because not all Gen AI programs are created equal, right? And on the one hand, you might have a program that takes anything and everything in the sense that it's trained on the entire internet and whatever comes out as a result of that. On the other hand, you have much more closed systems where the Gen AI program can even represent and warrant that everything that it's trained on and everything that creates the output is under license or is owned by the program. And therefore, it's not unlike licensing any, non-AI material in the sense that you're going to get reps and warranties that cover ownership and your right to use it in your film, and they'll even indemnify you. So looking at those terms of service is really important as a practitioner. In terms of editing, I mean, I think it goes back to what we were talking about before, which is, I think documentary filmmakers are doing the same thing that they've always done, but now they have these amazing tools that allows them to short circuit something or allows them to do something on turbo, right? An example that we talked about in our pre-meeting was what's called frankenbiting. And so for people that don't understand or know that term, frankenbiting is something that documentary filmmakers have been doing for a very long time. And it involves splicing documentary interviews or any kind of documentary audio and grabbing certain words or deleting them or editing them so that the filmmaker can get a clear statement from the subject. So an example might be, let's say I'm a filmmaker and I interview David for 8 hours, right? And you get the one sentence that I wanted you to say, except you didn't get one word right, right? So I have to look through your 8 hours of interviews. I have to find the word that you actually said correctly, and then I splice it in. So that's frankenbiting, and people have been doing that for decades. The difference now is that with AI, I can put your 8 hour interview into a program and I can get you to say whatever I want, right? So filmmakers are still dealing with the same ethical questions, right? But it's just easier to get the exact result that you want in a way that's maybe not transparent. It's not easy to spot anymore. And the lawyers have to know this, and we can't necessarily identify it when we see it. So again, a lot of these issues are not situations where there's a legal remedy, right? Maybe I made you say something that's not defamatory, doesn't place you in a false light. It doesn't really change the nature of what you said, but is it ethically okay? I would say sometimes it is and sometimes it's not, but there's no one clear standard, and that's the issue.
And we've
Yeah,
already seen a bunch of litigation relating to this. Our president brought a claim that may or may not have been Frankenbiting done by AI, but it was certainly a Frankenbite claim against CBS relating to Kamala Harris's interview. He's now got one going against the BBC for the way they edited one of his speeches. I know that there have been a number of other instances where platforms, including PBS, have refused to run a film because of complaints that came in from outside parties about the language of interviews having been edited inappropriately. I'm not suggesting in any of those instances there was anything inappropriate, but just it opens the door to claims whether or not there was really inappropriate editing. And we're starting to see some organizations come up with solutions for this to try to maintain credibility. My colleagues at Frontline have been doing what they call the Transparency Project. We publish the transcripts of most of our interviews, the people who appear in the films. We often publish the entire video of the interviews, subject to mild editing for either defamation concerns or some other kind of issues that might come up. And it's very popular with audiences. Good.
It's very interesting, and I guess the question I would have is, from the litigation perspective, does that help immunize you from liability in the sense that, oh, there's one thing out there that people are viewing that's been mass distributed and it's in the news cycle, and then maybe there's another stage you have to go through. It seems like a good step towards solving the problem, but it's an interesting distinction.
It was an interesting risk, and I will tell you, we had a lot of conversation about it because we know that there are people out there that are poring over these transcripts and these videos and trying to compare it to the film and trying to point to discrepancies. For me, at Frontline, it's given me a great deal of comfort because our transparency makes the filmmakers and their editors very alert and very careful about what they do in the editing process. But when it was first proposed, I'll admit that I was a little nervous about it.
But it kind of it goes back to this core concept we've been talking about, which is transparency, trust, right? And accountability in terms of being able to go back to the source materials. Um, I guess, Amanda, question for you, if we really sort of drill down to the most practical level for our audience, for the practitioners who are out there, what are some of the practical steps that you all are taking in your practice? And you guys can jump in on this as well, in terms of how you're advising clients, what the process is, how you're protecting yourself, what are some best practices to make sure folks are aware of this and you're catching things as best as you can.
Yeah, absolutely. Well, to pick up on something Chris said, I think the first step is to have a full inventory of what we're dealing with. What's been edited, what's been franken-bitten, if I may invent a verb here. What are we dealing with? And I think this sort of shadow AI use, or whatever you want to call it, is a real risk, and something that we want to make sure that clients are really comfortable disclosing, because we can only protect them to the extent we know the full landscape of what we're dealing with. So I would recommend that as a first step. It's really important to know what you're dealing with. And then, it's very case by case. I think, as Chris mentioned too, some cases of editing are going to be okay. Some are going to be riskier than others. One thing, I primarily represent media companies, and one thing people on our side of the bar are aware of is we don't want to be so cautious as to sort of chip away at the First Amendment, overall, and create an industry standard where maybe the floor is a little bit higher than it needs to be. That said, we also don't want to expose our clients to risk either, so there are a bunch of considerations in mind. But yeah, I think having the inventory and establishing the rapport with the client that, it's best for us to know so we can protect you are the key practical steps I would take.
I guess I would add that fact checking is absolutely critical, and in many instances, one of the first pieces of advice that I give to independent filmmakers who come to us at the clinic is that they should have somebody who was not part of the creation of the story, not one of the advocates for the story, who's actually doing some fact checking. I mean, I come from a journalism background. I worked in newspapers for a long time. At the Chicago Tribune, the old saying was, "If your mother says she loves you, check it out." Uh, and I, as it's funny, but it also has got a real ring of truth about how to best protect yourself against lawsuits. And if you can bring people who are there to report against your own biases, who are checking the facts really carefully, like the New Yorker magazine was famous for and still is famous for, In a potentially controversial film, that's one of the most important best practices I can think of.
Yeah, and I would just add, just to go back to transparency, I think it's more than transparency with the film team and with counsel. I think filmmakers need to be transparent with other stakeholders like
Mhm.
distributors and broadcasters, and in particular with insurance companies, right? I think the worst case scenario would be you get a claim on some AI generated material saying that this is infringement or it violates somebody's right of publicity or it violates one of the deepfake laws, and you're not covered by insurance because you either didn't disclose it or you answered a question on that insurance application falsely because you used a program that didn't get the requisite representations and warranties. It's interesting because I talked to an underwriter maybe 2 or 3 years ago, and I asked them the question, what do you think about the use of AI materials, and are you going to insure them if you get claims on them? And the answer was, we'll insure them as long as clients are engaging in AI use responsibly. So I said,
Hmm.
well, thanks for the non-answer, but that's not all that helpful. But I think years on, I think things have changed a little bit. And as I mentioned before, responsible AI use to me means disclosure with your insurance company. If you're not getting the reps and warranties that would be nice to get from a closed system and you're using a more open system, at least explain the program that you're using to the insurance company so that if you get a claim, they can't wriggle out of coverage.
It's a great point, and it goes to a question that's in the chat here that I was meaning to get to. Professor Jay Doherty from UCLA, who joins many of our seminars, as many of you know, was asking specifically, do these contractors between the producers and creative contributors, or the distributors and financiers, include provisions that require these types of disclosures, including disclosures around things like script annotation he mentions, and he also asked about E&O clearance procedures. And I guess part of what I hear you saying is, in part, the answer is yes. But even if they're not necessarily required as a practice, it sounds like you're volunteering this information. How do you advise clients in terms of that disclosure?
Yeah, it's a great question. I'll start with the insurance one first. I mean, E&O insurance applications, if anybody's ever looked at one, there's no one size fits all application. And half those questions are almost impossible to answer for a given film because it just doesn't apply. And so very often, rather than checking a yes or a no or an NA, you're having to supplement it with an explanation for why this question isn't quite a yes or no answer, right? So even though most of these applications have not been updated in years and they're not asking about AI, and for the most part, these clearance procedures are not addressing AI use, I still think disclosure's the way to go, particularly in a world where there is a lot of litigation around these issues, and we don't know where claims are going to come from. So better to be transparent than to hide it. As far as contracts go, we are drafting contracts that address the use of AI. So in most cases, when particular crew are being hired, there is a prohibition against the US use of AI unless it expressly given permission by the producers of the film because you just want to know exactly what's going on.
Great. So then if we dig just a little deeper into that conversation or that subject, we had talked about record keeping earlier. It's kind of a pedestrian subject for most folks out there, but for lawyers, this is the good stuff. So what records are you really specifically advising your clients to keep along the way that are the most useful from a legal and risk management perspective in anticipation potentially of getting claims or having to deal with these issues?
It's another one of these situations where creating a log is probably really valuable and important. A log that will record what programs or platforms were being used, how they were used with respect to which particular pieces of content, uh, which prompts were used and how the prompts were entered as well. Uh, My preference right now, quite frequently, is to tell clients to prepare this in a setting that could be privileged or work product, working with counsel. But in many instances, that's not always going to be possible. Uh, but the more information you have about how something was created, generally speaking, again, assuming ethical behavior and reasonable behavior, back to Chris's point about what the insurance company said, having documentation is going to be helpful in dealing with potential problems down the road. Again, back to the Archival Producers Alliance, I think they've got some really good guidelines on record keeping and what should be recorded and how it can be recorded in a way that that's really clear and usable after the fact. Um, and so I urge people to go take a look at that if they're interested in the record keeping question.
Yeah, one thing that comes to my mind that Chris mentioned previously is the license terms and the user terms for these platforms as well. I imagine that's can go a long way, Amanda, to showing you've done your homework at least when you're getting these types of claims.
Yeah, absolutely. And I mean, it's also useful too for copyrightability, which I know we're going to get to, but showing your homework is absolutely the best practice, just as a matter of record keeping, and then yeah, just to foreshadow our copywriting discussion as well.
Yeah, well, let's jump into that. So, a new topic here, obviously copyrightability. It's familiar to lawyers. There's a new conversation that AI has God, I'm going to say that AI has prompted, to use a terrible pun here, when we're talking about what is copyrightable. And, the creative folks, the filmmakers are sort of finding themselves in this new conversation where they're talking to the lawyers about, how do I protect my work if I'm using AI in it? If I use AI to do X, Y, or Z, can I still get a copyright? Before we get into sort of the practical tips and maybe the prompts and some of the other elements, Amanda, um, what's the big picture you're thinking about here for your clients when we talk about copyrightability, specifically in the context of documentaries?
Yeah, absolutely. The big picture is that it's changing and it's very fluid. We have a couple of very, very few number of cases that are giving us some guidance posts, but the whole thing is very unsettled. So, for example, as it stands right now, it seems like purely generated AI works that might be used in a documentary are not going to be copyrightable. That comes from the Thaler case, which was decided at the circuit level, and then the Supreme Court declined to hear it. So that's sort of where things stand right now. We have other cases, for example, where somebody inputted, scores of prompts and created a comic book, and the Copyright Office found that the prompts were copyrightable, not all of the output was. We have cases in Colorado and also recently filed here in the Central District that have sort of more extensive records of human assisted AI generation. We have one of my favorite examples is a piece called A Single Piece of American Cheese, or something to that effect. Don't quote me on the exact title, but there, the people seeking copyright had extensive records of how that particular piece was created, and they were able to get a copyright in their work. But right now, I mean, it's still very much a practical concern for filmmakers, and filmmakers should think carefully about how to put as much of a human fingerprint as possible on AI assisted work. These questions raise chain of title implications. So it's just good to be aware of and to keep an eye on as well, because this doctrine is evolving quickly.
Yeah, and so in the context of these documentary films, obviously, to me, it's so interesting because there's so many pieces to what can exist within the context of a documentary. Oftentimes, in the context, let's say, of a scripted series or a film, there's this idea of where does the idea come from? How are the characters being generated? But it's kind of a different conversation around a documentary where there's the interviews, there's the human element to it, there's the storytelling quality to it, and then there's using AI to amplify, I imagine, all of those elements. And I think that the question on everybody's lips is sort of where do you draw the line, right? What's enough human influence in order to get copyright protection? And how do you get over that barrier? I guess I'll ask you, Chris, because this is a tough one, especially. Why don't you jump in here? All right. It's on everybody's lips, this question. How do you talk to clients about how to get over that barrier?
Well, what I would say is if you're asking that question, you're probably in a dangerous place to begin with, right? If if the question begins, well, I did, I had an idea and AI took me the rest of the way. It wrote the script, it generated the video. I don't think there's a right answer, especially at this moment in time. But totally agree with Amanda that it's very much we just don't have enough cases to know where the line is. But I think it's disclosing the risks of not having copyright protection if the work just isn't human enough. Um, and then what is the knock-on effect of that? Well, you might have a chain of title defect. You could open yourself up to piracy. Um, it might be difficult to get a copyright registration. So to protect your work in court, in federal court would be very difficult. When you're registering a documentary for copyright, for example, you already have to grapple with the questions of, okay, what am I actually protecting in this film and what material needs to be excluded? Right. So for a typical documentary where you have archival material that you don't own, you have to exclude that material from the copyright registration. You're going to have to do the same with AI created works. And that's really where all of these cases started, were registrations with the Copyright Office gone awry, right? Some of them went through. I forgot which case it was where the registration actually went through, but because there was so much media coverage around it, the Copyright Office kind of pulled it back and said, well, hold on a second, you lied on your application. So I won't be surprised if there's more cases like that. But yeah, there's certainly a lot of interesting movement in this area.
Well, and I'll just say too, for the wonks among us, we had a really interesting chat a couple weeks ago with Professor Edward Lee at Santa Clara, who runs ChatGPT is Eating the World. And he's come up with kind of a novel way to think about copyright using AI in the vibe coding context that people may apply here. It's the selection and arrangement argument. And very, very broadly, it goes that by inputting enough prompts, you're adding sufficient human creativity to get a thin layer of copyright protection. I mean, that's super novel. It's not been tested. I just thought I'd throw it in there in case we had other copyright dorks among us. So
This one seems like it is going to develop, though. It's hard to imagine, given the likely uses we're going to see from big studios and everyone else of AI, that the law is going to stay static in the current form. But hard to tell whether that'll come from the courts or from Congress, if laws ever come from Congress again. But it's difficult to imagine that things will stay the way they are on this subject.
One thing that I
Yeah.
would, sorry, David, just one thing I wanted to add there is that I think as practitioners, we ought to be careful of a situation where, let's say a client says, well, I only did 2 prompts and I got the material versus, oh, I actually did 600 prompts and I got to the material. That's an important distinction, but it's certainly not dispositive, right?
Right.
Because we know under copyright law, you need something tangible, you need something creative. So even if you do something 600 times, it doesn't automatically become creative from a human authorship standpoint. So even if there's a lot of so-called work on the human side, it often will not rise to the level of copyright protection.
And so what sort of practical advice are you giving your clients about sort of how to use these tools? I mean, Dale, you talked about keeping track of prompts. You must be in this conversation constantly about where it might be a good idea and where maybe you should stay away from it.
I wouldn't say I'm in it constantly, but it definitely comes up frequently for all of us. And I think the answer is, in most cases, I tell clients that if they're going to be creating something using AI, that they are unlikely to be able to count on it being copyrighted. And that's something for them to think about going into it. Uh, as Chris said, there's only so much you can do to try to create, whether it's by arrangement and of the prompts or by some other theory to protect this work that you're going to be creating. So most of the filmmakers that I've dealt with, at least, have accepted the fact that if they're creating something, that they may have to live with people using it and violating what they think of as their proprietary rights.
It's interesting. And you mentioned this conversation is ongoing. One aspect of the conversation that we haven't really touched upon, and if we step back for a moment, is the broader conversation about should AI be used in these types of works or not, right? This is one of these issues where Hollywood is sort of really and I imagine the news media as well, really in conflict with itself, and all the way from the optimists and the early adopters to the doomers. And there can also be a cultural element to not wanting to take a side one way or the other. Are you seeing this play out within the documentary
Sure.
community as well?
Sure. And in fact, there a lot of people just instinctively are anti-AI, because of all the press about the fact that it's going to cost jobs, that it's going to replace humans doing any number of different kinds of jobs. But we've also seen some really good uses of AI that are really terrific. The first one that most of us were exposed to at Sundance years ago was a film called Welcome to Chechnya, where to protect the identity of people who might have been subject to prison or worse in Chechnya because that they were gay, the faces were reconstructed. They weren't just blurred, they were reconstructed using AI. That's a terrific use. It was fully disclosed. And yet there were still people who were opposed to it and who were critical of it because they just are instinctively anti-AI. We've seen it with voice recreations, the Anthony Bourdain example that caused all sorts of controversy, the Andy Warhol's diaries, as long as it's fully disclosed. And it's not done in a way that deceives anyone or steals rights from them. It seems like there are great uses for AI going forward, including for recreations. I mean, recreations have been part of documentaries going all the way back. Nanook of the North, one of the most famous early films, had recreations in it. As long as you're not deceiving people and taking something away from them, I think using AI is okay. But the repercussions for human workers are really serious, and it has caused a lot of the blowback.
One of the things that I guess comes to mind when you mention that is a very current topic right now in the news. Maybe it's documentary adjacent, but it's the film that was recently entered into, I believe, the Tribeca Film Festival, recreating on a sort of more of a scripted version of protests that occurred in Iran, right? And it goes to what you were talking about, which is it's probably a space where obviously documentary filmmakers are not able to get in
Right.
there to tell the
Right.
story. Um, but it's a fascinating conversation to have with the clients.
Mhm.
So let's jump into another easy subject here. Now that we've tackled copyrightability, let's talk about fair use, okay? And for lawyers who work on documentaries, this has always been a fundamental aspect of practice where you've added critical value, but AI is once again changing the conversation around this across the media spectrum. And Chris, you sort of got into this when we talked about the input versus outputs distinction a little bit. Um, Maybe you could set the table for us on what the fair use conversation looks like with documentary filmmakers these days, with these tools now being available. Oh, you're muted. Chris, I think you're muted.
You were
Bingo.
right. Sorry about that. Yeah, I was going to say, hate to say it, but again, a moving target, right? Because we are working with a fast evolving technology and also a lot of litigation at the district court level that will soon go to appellate courts. And so we're going to learn a lot more, I think, in the next couple years. But as you mentioned, there's really two central questions when we're talking about fair use. One is the input or the training question, right? Is the training of these LLMs on unlicensed material going to be fair use? And there's a few cases on that. And then the second question, which I think is actually more relevant and easier for filmmakers to get their heads around, which is the output going to be fair use, right? So regardless of how the LLM that you're using is going to be, regardless of whether that's infringement or fair use, is your material that comes out substantially similar to a copyrighted work that you didn't license? And actually, starting with the second question first, I don't think much has changed in that regard. I think we're still asking, and this is, reiterated with the Warhol Supreme Court case. It really comes down to transformativeness. Is the purpose and character of your use transformative from the original purpose and character of the use? But I guess even before that, you have to ask whether there is substantial similarity to begin with, whether you had access to the material. And if you have a bunch of prompts that say, well, listen, I want an artwork in the form of Warhol and this particular artwork, well, that's a red flag, right? As a practitioner, you want to identify those things and say, well, not only does this look like it, but you actually asked it to generate something that was exactly like that protected work. And this, again, another good reason to have good record keeping. So I think on the fair use output question, not much has changed, although there's an important case that survived a motion to dismiss that'll be really interesting to track. This is the New York Times versus OpenAI case, where the New York Times is saying, well, listen, ChatGPT can sometimes reproduce whole portions of our articles that look pretty close to the original articles. So they're able to establish, if they're able to establish that that's the case, they can establish market harm pretty easily under the fourth factor of fair use because people can just go to ChatGPT to read the news rather than New York Times, getting subscribers to read the same thing. It'll be really interesting to see how that case evolves, of course, because with those New York Times articles, we're dealing primarily with facts and theories and historical interpretations of facts, all of which is not copyrightable, but the expression of that as a whole is. And I have looked at some examples of some of the excerpts that ChatGPT generated next to New York Times articles, and it's actually quite fascinating. It's very, very close. I would not have thought that ChatGPT would generate something that close. So we're tracking that case. That's an important output case that we'll want to see where it goes. In terms of the input, there's the Bart's case, there's the Kadri case, and in both cases, they found that the training of an LLM on unlicensed material was transformative enough for it to be fair use. But they've also been very, very careful in those cases to say this is a very limited decision. And if we were talking about the reproduction of works as a whole, where the output was substantially similar to the underlying work, our opinion would probably be different. And the issues in those cases that there was no evidence of that. It was really limited to the input question.
Let me ask, how does that translate into a documentary filmmaker getting into trouble when using tools like this? Or you're reviewing a cut and you're looking at something that's been created with AI and you're concerned that there's a potential substantial similarity issue.
Yeah, well, the first question is which program did you use? And again, returning to the question of is it one of these open systems where it's the Wild West? It could have drawn from anything, right? And so we're looking at the prompts to see what you were trying to create, how much risk is there in terms of directing the LLM to produce a specific result. At the other end of the spectrum, you have archives that they have proprietary LLMs that are working on a closed system using only licensed or owned works. And I can imagine how that might be limiting creatively, right? Because you're working with less works, but at the same time, from a risk perspective, it's so much lower because you're getting the reps and warranties that you need from the licensor. In most cases, they'll even indemnify you from claims, which is great. And then when it comes to insurance, it should be an easy thing to cover because it's just like any other archival license in the sense that you're getting those reps and warranties and the indemnification. With the open systems, they often ask you to indemnify them in the event of a claim. So it's pretty much the exact opposite situation.
Yeah, and of course, there's the question of ownership of those materials as well, depending upon the licenses, terms that are in place. Amanda, jump in here. What are you thinking in terms of how you're seeing your filmmakers work with these tools and when a fair use kind of analysis is coming up in your conversation with them?
Yeah, absolutely. Well, I'm definitely tracking the New York Times versus OpenAI case. That'll be interesting. I think several of the studios have sued the AI platform Midjourney too, which, just to set the table, they're alleging that Midjourney can produce very near replicas of their intellectual property. So beloved Disney icons, for example, things like that. And I think that'll be a really interesting test of the fair use doctrine in the output context as well. Yeah, I mean that was my primary ad. I think this is unsettled. I think, as Chris said, substantial similarity kind of remains the grounding point. If the output is substantially similar to a copyrighted piece of material, I think you're going to be on some fairly shaky ground. Yeah, I think it's definitely something we as practitioners need to flag.
Dale, do you want to jump in here and add anything to the
I
discussion?
don't know that I have much to add. I think that's a really smart analysis from both Amanda and Chris on this front. I mean, we haven't talked much about right of publicity. That's another place where there's a really strong potential for claims when AI is used. I mean, it's a little less likely to be inadvertent, and some of what we're talking about, especially with the open systems, are inadvertent situations where the filmmakers might not be intending to copy. It just happens. In the right of publicity context, it would be a little more intentional. Again, one of the key issues from my perspective is always, to be really transparent and ethical about things. And if something appears like it's close, that's usually a very intense conversation between the counsel and the filmmakers. Because the truth is, most of the filmmakers I deal with, at least the independent filmmakers, probably the two of you as well, can't afford the litigation, whether they've got insurance or otherwise. They can't afford the distraction and diversion. They can't afford the impact on their distribution, which may be very severe. And they can't afford even the legal fees up to the time of their deductible being filled.
Yeah, and I think big picture, I mean, I think a through line for this entire conversation is that, the folks we're talking about who produce these documentaries, they're often really committed news people. They're committed storytellers. They care deeply about the subject that they're bringing to the world. And I think when they're in this conversation with you, they want to make sure they get it right, right? They respect other people's work as well.
Yes.
Think that in the kind of work that you folks do, there is sort of a gut element, I think, that underlies all of this in terms of a sense of fairness and what's right. So as we move forward, we've got a few minutes left here. Maybe I could just sort of, go around the houses here and ask each of you to sort of share with us a parting thought on, piece of advice you would give to either practitioners or to your clients today as they continue to navigate this. Look, it's a very competitive landscape, obviously. Things are only getting more complicated, but some things seem to remain the same. Amanda, maybe you could get us started.
Yeah, I mean, I'll start with the sort of the big picture thing that animates me, which is our job as I see it is to help our clients tell a story and to help them keep telling stories if that's what they wish. So that involves minimizing the risk of litigation. That involves all the things we've discussed today. But I think having that as a North Star is really important in thinking through all of these issues from an ethical standpoint, from a legal standpoint, from a practical standpoint. And otherwise, we're here to empower our clients to tell their story.
Fantastic. Dale, maybe you could jump in next. And I'd also mention we had one other question in the chat here that kind of goes to something you've talked about, which is fact checking. And is AI being used for fact checking experience? And how are you thinking about that moving forward?
Really interesting question, and I think I'm glad that it came up. I mean, people are using AI for fact checking, and also for defamation and privacy review, and I would say with mixed results at this point. For one thing, everybody knows about hallucinations, so I'm not here to scare everybody about hallucinations, but if you're using AI for fact checking, you still have to fact check your fact checker, because mistakes get made by the AI just like they get made by people, but I think at a higher rate in many instances. And as we've all seen in the legal context, judges are getting more and more aggravated and are taking more and more severe steps to address the hallucinations that are not being fact checked by lawyers. I think the same thing will happen in the defamation and privacy context. On the vetting side of things, there have been a few attempts to create vetting software using AI. I've seen the demonstrations of it. I have not actually used it. The problem is that the AI will identify everything that might be a problem, which actually creates more stress and more concern than really needs to be shared with clients or frankly with the lawyers themselves. So I don't think the vetting software is quite there yet. From a fact-checking standpoint, as a starting point, it may be useful for checking particular facts. I'm not sure I'd rely on it for an entire documentary film. And again, it would have to all be double checked by someone human who has real judgment to bear.
It's a great point. We talked about AI replacement. We didn't get into the piece about lawyers worrying about their jobs, but I think your point goes to the value of human judgment, especially with folks like you have been experienced for a long time. Uh,
Absolutely.
Chris, maybe you could have the last word. And there's a question in here also about going back to fair use. And should there be maybe a more specific notion about how fair use should be applied in the documentary context? Not sure if that's something you want to touch, but if you had any parting thoughts on that as well.
Sure,
But
it's funny because as an office we were talking about this on Wednesday, the extent to which there are cases that state that documentary filmmaking is part of, the one of the stated purposes that automatically are fair use. And the answer is not really. I mean, there are cases that kind of say that, and we certainly quote them in our fair use opinion letters, but it's not among the stated purposes that for which the fair use doctrine was actually created under statute. However, it has all of the hallmarks, especially with a pretty straightforward talking head documentary, for something to be transformative. So it's almost like a head start on fair use in the documentary context, but certainly not automatically. Yeah, Dale, you wanted to say something?
Yeah, I don't want to interrupt you, Chris, but I would highly recommend to whoever asked the question and anyone who's interested, the 10th Circuit's recent decision in the White Monkey case, which really goes through step by step on all four of the factors to talk about why documentaries, at the very least, are more likely to qualify for fair use than other types of content. And I agree with Chris. It's not a presumption, although I've argued it's a presumption in the past, and I certainly believe it should be a presumption for documentary filmmakers. But the White Monkey case is super helpful for documentary filmmakers and their lawyers.
And thank God that decision got
Came down the
reversed.
way it
Oh
did.
my God.
Yes,
Yeah, I mean, so if you
absolutely.
have a few hours to read that decision,
It's a long one.
it's a long one, but it's all good, and it's almost like which of these great quotes am I going to use in my
Yes,
opinion letter? So very, very good.
absolutely.
Yeah, in terms of final words, just to kind of piggyback off what Amanda and Dale said, I would say don't be afraid of the technology as a practitioner. It's here. You have to embrace it in some ways, in the sense that you have to be comfortable with it. You have to understand how it works and how your clients are using it. But there should be a human at the end of every process without fail, right? So on the vetting side, as practitioners, where probably most of us are using some kind of law AI tool, you still have to check the work. There's a lot of hallucination cases, and even short of that, it's maybe not thinking about certain things that a human would. So you have to double check that work. And for clients, the similar thing applies. If you're creating something that is largely created by I think a human really needs to step in and take a look, not just for legal issues, but also for questions of audience engagement. I had a client that was producing a true crime doc, and they decided very early on that they wanted to do 100% of the recreations through AI, and they recreated a lot of the archival materials through AI. We worked through all of the legal issues, but when they put it in front of a test audience, it did not work. People could tell. People were angry. And so they went back to the drawing board and had to shoot a lot of recreations and use real archival material. So I think that kind of feedback, whether it's legal or questions of whether it's ethical or thinking about whether an audience will accept it, all questions that they should be asking themselves.
great, fantastic point to close on. I think, again, it goes back to some of these core principles we've been talking about: trust, integrity, the relationship to the audience, fidelity to the story. And obviously, your clients are very fortunate to have you in their corner as they confront all these issues and work through them. I want to thank you all for sharing your expertise and your insights today as well. It's been a real pleasure to have this conversation with you, and we hope you'll come back and talk to us again.
Be
Thanks,
delighted.
David.
Thank you for having us. It was really
Yeah.
fun. Thank you to my fellow panelists. That was terrific.
Same. Thanks, Dale. Thanks, Amanda.
Thanks, everyone. This was awesome.